Are we ready to begin? Good afternoon, ladies and
All
gentlemen,
right, go.
and welcome
No,
to the House Conduct Committee. Before we begin our sexual harassment training, I would introduce to you our speaker, the Honorable K. Joseph Shekarchi. Speaker?
Thank you, Chairwoman. Ladies and gentlemen, colleagues, and the public, thank you for being here today, either virtually or in person, for this very important training session to prevent sexual harassment. I'd like to acknowledge today's organizer, Conduct Committee Chairwoman Camille Vella-Wilkinson. For those of you who don't know, Chairwoman Vella-Wilkinson has vast experience in this field. She is a retired naval officer who crafted training programs to help naval personnel identify and prevent sexual harassment. She's also worked as a contract employee for Lifespan in the field of sexual harassment prevention, and she was a member of the Human Rights Commission. In her private life, she runs an employment agency called Hire and Hire. She is vastly familiar with employment laws, sexual harassment prevention, and I can't think of anybody better to lead the Conduct Committee and this training session today. Joining Chairwoman is Tina Christie, the Senior Compliance Officer from the Rhode Island Commission for Human Rights. Tina has been with the Commission for nearly 25 years, joining them in May of 1996. She's a graduate of URI with a degree in political science and government. And like Chairwoman Vella-Wilkinson and myself, she also lives in Warwick. Joining Tina in the presentation today will be Casey Brody, a staff attorney for the Human Rights Commission. She's also the chief legal counsel for the Rhode Island Department of Revenue and is a former prosecutor in the Office of the Attorney General. She received her undergraduate degree from Boston College and her law degree from the University of Connecticut. Welcome to you both. A big thank you to you and to Chairwoman Vella-Wilkinson. Leader Blazajewski has a few comments. This is such an important topic. I cannot thank you and my colleagues for being here today. Thank you.
Thank you, ladies and gentlemen. Thank you, committee members. Thank you, Mr. Speaker. And thank you, Chair Vella-Wilkinson, for leading this very important training. And thank you all to the members who are participating. As Speaker Shekarchi said, this is very important that we pay attention to this training and integrate it into our lives. So with that, Madam Chair, I'll leave it to you to begin this important training session. Thank you.
Thank you very much, Leader. Ladies and gentlemen, I want to take care of some minor housekeeping before we launch into our training. To begin with, the handouts that our trainer will be referring to later on this afternoon can be accessed through the state website in the Documents folder. Also, for those of you who are viewing at home on WebEx, if you have a question, please wave to us, or certainly you could send a text message to the clerk so that you could be acknowledged. For those members who are in the overflow rooms in the State House, we have a separate microphone that's set up on the side of the House Lounge, so you'll have an opportunity to come and articulate your question. Yes, ma'am. Yes. And so, clerk, would you please call the roll?
Yes. Chairwoman Vella-Wilkinson.
Here.
First Vice Chair Norrie.
Here.
Second Vice Chairwoman Vella.
Here.
Representative Abney.
Present.
Representative Ackerman.
Here.
Representative Chippendale. Representative Diaz. Representative McNamara. And Representative Serpa.
Here.
6 present, 3 absent.
Thank you very much. Ladies and gentlemen, workplace sexual harassment imposes a range of costs that impact individuals, including the victims, the perpetrators, and the bystanders. It impacts employers, the government, and society as a whole. These costs include lost productivity and other costs such as for health care, complaints and investigations, as well as the lost well-being of the victims. Please turn your attention to our trainer today, Ms. Tina Christie, and I ask you to mute your mics. Thank you.
Good afternoon, thank you, and thank you for having me. So I'm Tina Christie from the Commission for Human Rights. I'm a senior compliance officer at the Commission. I also do the sexual harassment trainings and mediations. So the first exercise that I would like to do is if everyone can just pull out what says at the top, risky behavior. I'm just going to give you about 2 minutes to review the questions and answer them, and then we're going to go around the room and discuss it. Also, I'd just like to mention that this is a very interactive training, so at any time, if you have any questions, please just feel free to, just jump in and ask.
Ms. Christie, before you begin, I see that Representative Diaz is also here, and I'd like her attendance documented. Thank you.
Representative Kennedy is here as well.
Thank you, Representative.
And also, I don't know if, Madam Chair, if you don't be recorded as a positive for attendance, but I'm here, Joe.
Thank you, Chairman. And I see that Chairman Corvese is also with us.
Teresa Tanzi's here as well.
Hi, this is Representative. And Representative Felix as well? I'm not sure if I was marked.
Yes, you are. Thank you. And thank you, Rep. Tanzi.
Yeah, Chairwoman, this is Jay Edwards. Did you get me as well?
Yes, thank you very much, Representative Edwards. We have you as well.
Catherine Kazarian here too.
Thank you.
I think that only took the role of the committee.
Before we sign off this afternoon, anyone who has not been recognized, please call your names out, but I'd like to continue with the training. Thank you very much. Go ahead, Ms.
Okay, thank you. So I would like to ask for a volunteer who would like to read and answer number 1.
Me, right here.
Okay, go.
I don't have the form. I'm going to step up with you.
Oh, okay. So if you read the question and then answer it, now you're going to know my answers.
Is it a mistake to hug a colleague you have not seen in a while? Yes or no?
Yeah. Is it a mistake?
Not necessarily. Well, in COVID it is, but not necessarily. If they're accepting of that behavior and you have that relationship, then it's, I would say it would be acceptable.
Right, so that's a great answer. If you think that you're gonna, hug someone, physical touching, especially in the workplace, is like a super, it's something that's very serious. So if you're going to touch somebody in the workplace, you want to make sure that you know that the relationship between the two of you is such that they are accepting of the hug, and the hug is something that is wanted. So it's the perception of that individual who will be receiving the hug that you really want to be concerned with. How does this person feel about me hugging them? Are they going to be offended by it? Do they like touching? These are the things that we should consider in the workplace. And I mean, if you feel like you really need to hug somebody, you really want to know how they feel about you and whether or not you should extend that hug. Now, if you really feel like you want to hug somebody, but you're not sure that you're going to offend them, what could you do? Would there be something that you could do before you hug them?
Ask them.
Ask them, right? Wicked common sense stuff, you know what I mean? So if you ask them and they say yes, then the hug is accepted. But it is risky behavior. That's why we put it on here, because touching in the workplace is risky. But thank you for that.
I'm available for any other questions.
Okay, perfect. Who would like to take number 2? Yes, if you'd like to read the question and answer it, that would be great.
Yeah. Put an arm around a colleague who is crying. Put an arm around a colleague who is crying.
Right.
I don't think that that's risky behavior if it's somebody you know and if you know they're in real pain. I think it's risky behavior if you just see somebody crying and walk up and do it. But if it's a colleague, you don't know what has happened to them. You know, they could have lost someone, anything. But so I don't think it's risky behavior if when you put your arm around the person, they don't move. If they do, then you should back off, I think.
Right. So, as we said in number 1, touching in the workplace can be risky behavior. Knowing how that person perceives you, and, if that person feels vulnerable at that time and doesn't want to be touched, there are reasons why we kind of set these boundaries in the workplace with regards to physical touching, because of these reasons, because the person might, perceive you as somebody that they don't want to be touched by, or they could feel especially vulnerable when they're crying. So, again, if you want to put a hug around a colleague when they're crying, what should you do? Ask. Perfect. Okay, who wants to take number 3? This is a good one. Yes?
Have a secret affair with a coworker who is not a supervisor or subordinate. Is it a mistake? I would say yes.
Okay. So, who thinks it's okay to have a relationship in the workplace if it's not a supervisor or subordinate? But in reality, people do have relationships in the workplace. I always ask when I do sexual harassment training, is there a policy against relationships in the workplace? Do you have one here for the House? Is there a policy? Okay. So a lot of places don't have policies and people do date in the workplace. My parents met at Apex and got married and had me. So if it wasn't for Apex and relationships in the workplace, I wouldn't even exist. One time I did a training and I did it to like 16 people, and there were like 4 couples because it was a very, concentrated area. They had a lot of things in common, and it just happened that, there were 4 couples in that sexual harassment training, and there was no workplace policy against relationships. What issues could occur when there is a relationship? Well, first of all, we know nothing's ever a secret, right? I put that in there for a joke, so you guys get my sense of humor. So what could the issue be with people having a relationship in the workplace? There's a couple. Yes.
So when the relationship ends, it may be a very uncomfortable situation to work with that person.
Right, not just uncomfortable, but can rise to the level of a sexual harassment charge of discrimination. I've seen relationships in the workplace when they go sour. Then one particular case where the woman broke up with a man, he started stalking her during working hours. And lots of examples of that. But the big issue was that the respondent did not do anything to take immediate, appropriate, and corrective action to stop that behavior in the workplace, which resulted in a charge of discrimination. So there's that, where the relationship can go bad. Yeah.
Someone gets promoted.
Someone gets promoted. That's another issue. Really shouldn't have somebody who's having a sexual relationship with someone else, supervising them or them being your supervisor. So that's another issue. And that happens in the state a lot. We don't have a policy against dating in the workplace either, but when, coworkers start to date and then people get promoted, it becomes an issue. There has to be some action taken if there is a supervisor and a subordinate who are dating, like somebody's got to get transferred. Hopefully not the subordinate, because that would look like, that would look like the victim, that would look like the person who is having the relationship with their supervisor is being penalized by being transferred out. But, I do this in mediations. You can be creative and make the workplace comfortable so that, everybody does their job in a hostile-free work environment. Who'd like to do number 4? This is a good one. Yeah.
Talk to other coworkers about sex behind closed doors. I'd say it's a mistake, yes.
Yeah? Does anyone think it's okay? talk about sex behind closed doors? Okay, we've come a long way, because a lot of people don't think that there's anything wrong with this if it's two people behind closed doors, even when you're at work. So I say you should never be talking about sex at work, right? What stuff should you be talking about at work? Work would be great, yeah. Kids, politics, sports, lots of things to talk about, but sex shouldn't be one of them. That should be something that's, you know, done after hours. So what could the issues be about, you know, two people talking about sex behind closed doors in the workplace? How could that become a hostile work environment?
There's just too much opportunity for someone to take something out of context, or to not really understand what your intentions are in the message. And if you're making them uncomfortable, oh, I'm sorry. I've been told to speak into the microphone. I think there's too much opportunity for, depending on your relationship with that person, there's too much opportunity for something to possibly be taken out of context in your message to them. And, you know, everybody translates particular language in a certain way. So there is an opportunity for you to make anybody uncomfortable in that situation.
Right. Exactly. So, you know, even if you think that there's two people who are having a conversation and it's not, you know, it's mutual, that might not necessarily be the case. Maybe somebody doesn't want to hear what the other person's saying, talking about sex. The other issue is that sometimes people can talk about sex in the workplace, but then one of the people decide that it's unwanted. That can turn into, you know, an eventual charge of sexual harassment if somebody decides, you know, I don't want to have that type of banter or relationship anymore. The other one is that even though they're behind closed doors, other people can still hear. And in the state of Rhode Island, it's the law that we work in a hostile-free work environment based on sex and a whole bunch of other protected groups. So if, you know, it can create a hostile work environment. You know, when you're in the ladies' room, you don't know, you see it on TV all the time, you don't know who are in the stalls. You don't know how thick the walls are. So talking about sex in the workplace is very risky, and, you know, you should talk about other things. Okay, how about, you know, we're going to skip number 5 because we don't have a lot of time, but how about number 6? Who'd like to do number 6?
Rep. Carson, did you have your hand up? No, she's waving, okay.
Thank you.
All right, I would say you shouldn't reward a subordinate with dinner. It's one thing to go out to dinner to discuss business, and that happens many times in the workplace. But I don't think that's an appropriate reward. I mean, if you want to give them a raise, you want to give them a bonus, you want to give them time off, maybe those are appropriate rewards. But to reward a subordinate with a dinner, no. No, I don't think so, unless it's a business meeting, and it shouldn't just be 2, it should be like the whole office.
Yeah. So,
or a small, you know, the certain people in the hierarchy, or whoever, I mean, it depends on who the person is, the subordinate. If it's the secretary and you want to take out, the president wants to take out the vice president, the secretary, and the, somebody else, you know, and they want to talk about business, that's fine. But not a reward, no.
right, so I think, did you want to make a comment?
Yes.
Okay. Thank you.
I agree with what Carol's saying, but there could be certain circumstances where you could reward a subordinate with dinner if you give them a gift certificate, and their reward is not dinner with you.
That's a great idea. That's one of my suggestions. So rewarding a subordinate with dinner is not appropriate, because who wants to tell the boss that you don't want to go out to dinner with them? Nobody. You know, because you might want that raise or promotion. But a boss should not be taking out a subordinate alone at all. So I suggest, because this is a practice that's been done a lot in the past, and maybe not so much now during COVID, but just being alone with a subordinate is not a good idea. I've had a few sexual harassment charges resulting in, in this behavior. The boss asked me to go out to dinner. I felt like I needed to, and then, I was sexually assaulted, actually. When the commission investigates charges of sexual harassment, we can also do them at the same time when a criminal charge is filed. So if somebody is physically sexually assaulted, there will be criminal charges filed as well, and there'll be 2 investigations, one civil with the commission and the other criminal investigation. And also, I say, I know people have different hours, but lunch would be better. It's more casual, and always bring more than one person. Who would like to do number 7? Okay.
First of all, I would say that it is positively, absolutely not a good idea to ask a coworker on a date unless, you're equal in your job. There's no linear, promotion, not promotion that's involved with it. So if you know the person and they're working exactly like you are, it may not be inappropriate, but I do think it's risky business.
Yeah. It might be risky behavior, but thinking about it reasonably, if there's 2 people who work together, not a supervisor or subordinate, one asks the other on a date, if there is no policy against dating in the workplace, I don't really see anything wrong with that. But what happens if the person says no? That's what I'm concerned with. What happens if the person says no and you're rejected for asking someone out on a date? What should you do? You shouldn't do anything, right? You should just let it go, because you're in the workplace now, so you don't want to ignore that person. You don't want to, walk away calling the person names or tell all your friends that you were rejected and have them shunned. You don't want them to have any negative consequences because they rejected your request for a date, right? But it does happen, and it would not rise to the level of a charge of investigation if somebody just says no, and then that's the end of it. So let it go. Who wants to do number 8? Yes.
Rep. Lombardi, are you waving for attention? No? Okay, thank you.
Number 8, should you tell a co-worker that suit looks great on you? I'm going to say it's not harassment, but it probably is in this day and age. To me, it's a compliment. I don't think it's any more offensive than saying blue is your best color, or I like your new haircut. And to me, that doesn't rise to the level of harassment. It wouldn't offend me. That's my opinion.
Okay. Anybody else have any comments on that? Okay. So I'm sorry. Okay. Yeah, please go.
Sorry I'm commenting so frequently, but you're actually complimenting the suit in that case and not the person. So I think but it still could make that person uncomfortable. And it depends, again, everything really depends on your audience and your relationship, I think. Everybody, I think most people enjoy a compliment, but you could still, if you say that suit looks great on you, then you're saying that, well, he has a very nice suit. If it says, you look great in that suit, then that's a totally different comment. So you really have to watch, if you're going to make that type of compliment, what you believe is a compliment, then you need to be careful.
Did you already take this class with me?
No, ma'am, I haven't.
Huh?
I have not.
Okay. So that's, you know, he said two things that I always say: know your audience. I love a compliment, but some people don't, and it makes them uncomfortable. Okay, so paying someone a compliment in the workplace is you know, does not rise to the level of sexual harassment. But know your audience. If you think that it might make them uncomfortable, it's not what you say, it's the way you say it. So know your audience, and it's not what you say, but the way you say it. So if you say, "Hey, that suit looks great," and he did a great impression of somebody what I call a creepy person, right? Who's like, "Hey, you really look hot," and that's so it's how you say it too. And I, you know, if I'm going to give a compliment, I know, you know, the person that I'm going to give the compliment to is going to be receptive of it, and I know that it's going to be appropriate. So, you know, we're in the 21st century now, so things that might have been appropriate in the 20th century are not appropriate in the 21st century. So we all have to catch up. But, you know, just remember that if you want to make a comment about somebody's appearance, hair, shoes, clothes, anything, that it needs to be done appropriately for the workplace, right? That's a fun one. Who'd like to do number 9? Yes, please.
It's not working. Puts lipstick on before meeting with the boss. I don't have a problem with that, but you're making a few assumptions here. When you're saying the boss, are you talking that it's assuming it's a male boss?
I didn't say.
Because the 21st century, it could be a female boss.
Yep.
Putting lipstick on is just part of your daily routine of putting makeup on. I don't have a problem with that.
Mm-hmm. So all of these used to be gender specific back in the 20th century, and I changed them all to be, I think all of them, gender neutral. So it could be, you could say, it depends. Well, what if the supervisor is a woman and the person going in to meet with her boss is also a woman? Is that okay?
I don't have a, do you want, go ahead. I don't have a problem with, it's part of your makeup. I don't find it offensive.
I have to agree with me. I mean, I wear lipstick, I put it on constantly. I'll, you know, meetings, anything. I don't care who I'm meeting with, I wear it all the time.
Yep.
There is nothing suggestive about me wearing lipstick. And if that's offensive, I mean, maybe I'm from the wrong generation, but I mean, I wouldn't go out of the house without lipstick. I wouldn't go into a meeting without lipstick.
Neither would I.
So, I mean, I don't know why we even have to talk about it.
And before I have a meeting with my boss, I always touch up my lipstick. I don't think there's anything wrong with this at all. So the reason why I did put this question in there is because when I did this present training in the 20th century, a guy, a supervisor leaned back in his chair and says, if she puts on lipstick before she comes into my office, she's just asking for it, right? So look how things have changed in the 21st century. Everyone's like, there is absolutely nothing wrong with that, and there isn't.
I think Patty wants to say something.
You know, this is like bordering on the ridiculous. I mean, is it any more offensive than a gentleman straightening his tie in his office before he goes in to meet with the boss?
Right.
So, I mean...
I just put it in for fun,
Yeah,
that's all.
okay.
There's nothing wrong with putting lipstick. Is everybody clear on that? I might take that one out next time.
So, just to let you know, I don't wear lipstick. But, again, everything depends, in my opinion, everything depends on context.
Yep.
And location. If you're sitting, not necessarily in the House of Representatives, but if you're sitting in an office and you all have cubes, but you can see each other and you talk, and somebody says, I have a meeting with the boss, while she's dolling up her lips, you could make your coworkers uncomfortable, or you could give some type of a signal that, okay, we all need to do that as well, or I'm just dolling myself up for the boss. So you could have an issue with that. I don't think it borders on harassment, but I would say if you're going to put lipstick on and you do it in a powder room or the restroom or in an office with a closed door, so you're not seen doing that, then you're not offending anybody.
Right. Well, I don't think that someone seeing someone else put on lipstick would...
But with the commentary of, I'm meeting with the boss, it changes everything.
Oh, like like, if you know what I mean,
You're in a
wink, wink kind of thing?
Well, if you're in a group workplace, no, not necessarily. You could just be saying like, oh my God, I got a 10 o'clock meeting with the boss, and you're like Carol, and you want to make sure you look good all the time, then it could be trouble.
Okay. All right, the last one. Who wants to take number 10? Yes.
No.
Okay. So the question was, is it risky, is it a mistake to flirt with a coworker? And you said no. So who thinks it's okay to flirt with a coworker? I mean, it might be risky, right? It might be risky to flirt with a coworker, but it's not, it doesn't rise to the level of sexual harassment unless what?
Unless you're making them uncomfortable.
If you're making the coworker feel uncomfortable.
It depends on your relationship.
Yeah.
I mean, that's always clear.
Right. Well, it always depends on the relationship. Yes, go ahead.
They ask you to stop and you don't.
That's right. They ask you to stop, don't do it anymore. Perfect. I love that. Does anybody have any questions on anything we talked about so far? Yes.
Not a question, but more of a statement. I'm concerned with a movement towards it depends on your relationship with the person, because if we're in a group environment, whether we're over at the Met or even here in council chambers, and you've got a relationship with one of the other reps of the opposite sex, where there's that kind of playful on the borderline of sexual banter, and someone else, a third party, witnesses it, they're not going to understand that you have a different relationship. Potentially, they're going to feel that you're open to that type of banter. So I think that you've got to be very careful of the perception that you're also projecting to those around you, whether or not you mean to include them in on the conversation or the banter.
Thank you so much for bringing that up, because you're right. Like we discussed in about talking about sex behind closed doors, right? When you're in the workplace, people can, there's a potential for anyone to be able to hear you. And it's the same thing with sexual banter too. That can absolutely cause a hostile work environment for somebody else if you and a coworker or a colleague engage in sexual banter and they don't want to hear it. When it starts to interfere with their work performance or create an intimidating or hostile work environment, then that's a serious problem. So yes, I agree that these things are risky behavior, and what we discussed doesn't necessarily rise to the level of sexual harassment, but I call that third-party sexual harassment, by the way. So it's like not engaging in the behavior, but it's affecting other people in the workplace. So it's something, I'm glad you raised that, and it's definitely something to be very aware of. Any other questions or comments? Okay, so I'm going to just give you a brief overview of the commission. The commission has been around since 1949 upon the enactment of the Fair Employment Practices Act. And since then, we've been tasked with other laws that we enforce. So we enforce the Fair Employment Practices Act, the Fair Housing Practices Act, the law regarding HIV/AIDS discrimination, the Public Accommodations Law, the Civil Rights of People with Disabilities Act, the law regarding credit discrimination, in equal rights of blind and deaf persons to public facilities. So these are the laws that we cover. What we're going to be mainly talking about employment today. But if you had any other questions afterwards, I'd be happy to answer them about the other laws that we cover. So the Fair Employment Practices Act, we call that the FEPA, so you might hear that a little bit. I might just throw out FEPA, not realizing you may not know, so that's what it is, the Fair Employment Practices Act. Makes it illegal to discriminate against an employee or a potential employee based on race, color, sex, which includes pregnancy and sexual harassment, religion, age, 40 and over in employment, mental disability, physical disability, sexual orientation, gender identity, and expression. So those are the protected groups that we cover. And I did say age was 40 and over, right? 40 and over in employment. So if if a person files a charge of race discrimination, what races, like, just give me some examples of what races can file charges of discrimination at the commission. Yeah, name a race a race. So we're talking about race. A person could, huh? African American, what else? Caucasian, exactly. So every race is included under race discrimination, just like ancestral origin discrimination. So it's every ancestral origin. Sexual orientation is every sexual orientation. So anyone can file a charge of discrimination if they feel like they're being treated less favorably than other individuals outside of their protected class. We also cover retaliation. So if somebody files a charge of discrimination or participates in being a witness for a charge of discrimination, and they're retaliated against, they can file a charge too. And we also cover a law that prohibits applicants from requesting conviction records prior to the first interview. We call that ban the box. So let's see. So the process of filing a charge. We have 6 investigators. We all take turns being what we call information officer of the day. So if a person feels like they're discriminated against, they either call the commission, they used to come in before COVID, or even email. So we talk with the individual who calls to see if they meet the commission's jurisdictional requirements. One of the big questions that I ask when they're telling me the story is, are you being treated less favorably than somebody outside of your protected group? Because that's what discrimination is under our law. I also ask if they work in the state of Rhode Island, if there are 4 or more employees, because you have to have 4 or more employees to file a charge with the commission, except for disability. 4 or more employees in employment, that is. And also, do you work in the state of Rhode Island? Because if the person works in the state of Rhode Island, we can take the charge in. It doesn't matter where the employer is actually based, as long as the work is being done in Rhode Island. So if they meet all of those requirements, then we have them fill out some paperwork. Our EEOC project director takes that information, writes it up into a formal charge of discrimination to be signed and notarized, and then it gets assigned to an investigator. So the first thing that I do when a case is assigned to me is I try to bring the parties together for a resolution. And if that doesn't work, then I request information from both parties, conduct interviews. Sometimes we have predetermination conferences with a commissioner, and the commissioner will ask questions and sort of like work through the investigation with me, and then I make a recommendation. If there is evidence to support that discrimination happened, I would make a recommendation of probable cause, and if a commissioner agrees with me, they would make the ruling of probable cause. And then the case would either go to a hearing at the commission. We have a quasi-courtroom setting at the commission, and commissioners sit as judges, sworn testimony is taken, and then a determination would be made, which if finding for the complainant could be, Camille, Representative Vella-Wilkinson could probably answer this better than me, but they can receive back pay, damages, pain and suffering, 12% interest on top of that. Did I get everything? Yeah. And if there is insufficient evidence to support that discrimination happened, the case is closed. Does anybody have any questions on the commission's process? Okay.
I see Representative Carson has her hand raised.
Yeah, I had a quick question. Is there a statute of limitations on the complaint?
Oh, that's a great question, yes. So it's 1 year from the alleged date of harm. I missed that, but yes.
Thank you.
You're welcome. Okay, so does everybody have how to deal with sexual harassment in the workplace? Do you have that packet? Or that handout? So it may seem, all of these steps might seem, like common sense. But when somebody is being sexually harassed or otherwise discriminated against, and I always throw that in there too, because, you know, sexual harassment is the same type of other discrimination, and I kind of use this as a guideline for any types of discrimination. So, what happens if you feel like you're the victim of sexual harassment? The first thing is know your employer's sexual harassment policy, and hopefully they have one. Some places don't, unfortunately. The law only requires employers with 50 or more employees have a sexual harassment policy, but not everybody has to have one. Do you have one here? No sexual, well, I mean, I think that would be a great idea, to have a sexual harassment policy with a complaint process in it. So if there's a complaint of sexual harassment, folks know the steps that they need, who they can complain to, first of all. I think that's the most important thing. Because if an employer doesn't have a complaint process, how are they going to have the opportunity to take immediate, appropriate, and corrective action? Not everybody knows where they should go if they feel like they have to file a complaint of sexual harassment or any other type of complaint. The next one, ask the harasser to stop. Now, that's not always easy. I would think taking, you know, into consideration maybe even this work environment where you've had representatives working for a long time, and then you have new representatives, and when they come in, they might not feel as, even though allegedly you're all on the same playing field, maybe, you're all representatives, it might make a new representative feel uncomfortable, you know, asking the alleged harasser to stop, right? So, but if it's possible, that would be the first step, and hopefully that would be the end of it, right? The next one says, write a note to the harasser if they don't stop. Now, this is a good idea because when someone files a charge at the commission, they say that they did these things verbally, and then, you know, by the way, when a person files a charge, they're called the complainant. The employer is the respondent. But the respondent will say, they never told us. You know, so if there's no evidence that you ask them to stop, then it makes a sexual harassment investigation difficult. So we say an email is great now. Like back in the day, it had to be certified letter was the standard, but now we have email. So, you know, that shows that a person received that. Keep records. So like a journal, when people are discriminated against and they bring in a journal, that's real great evidence. Identify other victims and supporters. If it doesn't stop at the point where you ask that person to stop, you write a letter to your supervisor or the person who takes sexual harassment complaints and request a meeting. But I always say that there should be some evidence in writing to do this. So, I mean, I know not all of these steps can be followed, but it would really help an investigation if it was. And also, get materials of a good work record, because respondents, one of respondents' biggest reasons for, terminating somebody, maybe the person says they were terminated because they were sexually harassed and by the boss, and it was a quid pro quo situation. They didn't want to have sex with the boss, and the boss fires them. I have one of those right now, and the boss was like, no, they were a terrible employee. Like, that's why I fired her. It wasn't because she wouldn't have sex with me, So it's good to have, if you have any evidence of a good work record, so that you can refute the fact that they say you're not a good employee. Although, I do ask for things like performance evaluations and stuff like that just to double check and see who's telling the truth. So if this stuff doesn't work, then a person can come to the commission and file a charge. We also work with, when it comes to investigations of discrimination, we work with EEOC. We have a partnership with them, and although they have, you have to have 15 or more employees for the commission to co-file the charges that we take in with EEOC, it does provide a second set of eyes to review the findings. So that is what we do when we have charges of 15 or more and 300-day statute of limitations for EEOC. Does anybody have any questions on any of the steps you should follow if you feel like you're being sexually harassed or discriminated against? Okay. Well, this is the fun part for me. I mean, I really enjoy, risky behavior, but I love talking about the definition of sexual harassment because there's so many caveats. I really like to pull it apart. So does everybody have, and I apologize that it probably came in sideways for you, but it says sexual harassment in the workplace, guidelines and legal requirements for Rhode Island employers. Does everybody have that? Okay. So this gives a great definition of sexual harassment. Harassment on the basis of sex is a violation of the FEPA. Unwelcome, unwanted sexual advances or requests for sexual favors and other verbal or physical conduct of a sexual nature constitutes sexual harassment when there's three things: submission to or rejection of such, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decision affecting that individual, or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment, just like Representative Vella-Wilkinson brought up to us earlier. So, the first element of sexual harassment is that it has to be unwelcome, whether it's directed towards you or whether it's, where you're in that work environment where it's sexually charged. If it's unwelcome, then, it looks like it could rise to the level of sexual harassment. Verbal or physical conduct. So verbal conduct is, and does anybody have any examples of verbal conduct of sexual harassment? Like sexually explicit jokes, sexually explicit comments, anything that really is, any kind of comment that is sexually charged would be considered verbal conduct of a sexual nature. Yes.
Tina, that would also include passing on a sexual rumor, isn't that correct?
Oh, yeah, absolutely. And basically, anything that has to do with sex that's verbal would be considered verbal conduct of a sexual nature. Physical conduct of a sexual nature. Now, rubbing somebody's shoulders, like any touching is completely inappropriate. Rubbing somebody's shoulders, not appropriate. I say, I learned this from one of my participants. I'm super lucky. I learn these little things when I talk about sexual harassment from participants. Bathing suit areas, okay? We all know what the bathing suit areas are, right? You cannot touch anybody in the bathing suit area. That is an automatic charge of sexual harassment, one time. I mean, if it's unwanted, but obviously. And, especially if you do that in front of somebody else and they're offended, even if the person that you do it to isn't offended, I'm sure that there's going to be somebody who's offended by that. So I've had charges filed before on, a one-time slap on the rear, or, touching somebody intentionally, obviously, in the bathing suit area. So don't do that in the workplace. Explicit or implicit, like we talked about, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment. So I see a lot more implicit sexual harassment now because some people know that they're not supposed to talk about, sex at work. They're not supposed to make a quid pro quo comment to somebody saying, if you have sex with me, you'll get the job. Well, we don't see that as much anymore as like, oh, if you play your cards right, you'll really go far in this company. Or something like, yeah, you know, I know women who wear short skirts usually get promoted a lot quicker. So these are the things that we look at now, and like, it seems to be more of a trend in sexual harassment. So if you say a comment like that one time, okay, that's not going to rise to the level of sexual harassment, especially if, you know, the boss says, if you have sex with me, you get the promotion. You don't have sex with the boss, you still get the promotion. There's no, Casey, what's that word I'm looking for? Can't think of it. But there's no negative impact on the employee, right, for that one time. So we look at the frequency and severity of those things. Well, actually, that might not have been a great example, because quid pro quo, well, actually, there was a quid pro quo case, and because she did not have sex with the boss, but she still got the promotion, she didn't prevail. But, I mean, that case was a long time ago, so it might be interesting to see what happens, you know, in this 21st century. But, so with implicit sexual harassment, though, you know, like, girls who wear short skirts, you know, get promotions in this industry or whatever. We look more at the frequency and severity of the acts before we can say that the particular behavior rises to the level of sexual harassment. Also, interestingly, is if the conduct has the purpose or effect, which I think, you know, also goes to Representative Vella-Wilkinson's point. So you might have the purpose of sexually harassing somebody by saying, if you sleep with me, you'll get the job, right? But if you're somebody who comes into a meeting and you're telling jokes of a sexual nature or sexual innuendos or making sexual comments, you might not have the effect, you might not have the purpose of sexually harassing people, one or more people, but you might have the effect of sexually harassing someone. So you can't, like, playing stupid and saying, I didn't know, is not an excuse anymore. People just have to be responsible for their behavior when it comes to sexual harassment in the workplace. Does anybody have any questions on that definition? So interestingly, I'm just going to bring up a few more points about our sexual harassment law. So the employer is responsible for the acts of their supervisors with respect to sexual harassment, regardless of if the behavior was authorized or even if it was forbidden, and regardless of whether the employer knew of the occurrence. So I feel like what that is saying in regular person's terms is that the supervisor is an extension of the employer. So they are held to a higher standard when it comes to allegations of sexual harassment. And in a case that I recently had, there was a 17-year-old who was working at a fast food place, and her manager, she believed he was her manager, raped her a few times and told her that if she told anybody, he would kill her family. So the respondent, remember who the respondent is? The employer was trying to say he was not a supervisor, so he wasn't an extension of the employer. But so that would be something that we look into and investigate. Why did she think that he was a supervisor? And they're saying he's not. Well, he gave orders. He made schedules. He told people what to do on the shift. He was a supervisor. So that is just, that's just something that I wanted to point out. So whether the employer knows or should have known of the conduct, they are responsible unless they can show. So, I think that this is really important, that the respondent is responsible for the conduct if they know or should have known and fail to take immediate, appropriate, and corrective action. So, I mean, that's a tough one, knows or should have known. That means that employers really need to be on top of this stuff and know what's going on with their employees. And in sexual harassment training, I have seen this too, like supervisors will just say, oh, I don't want to hear it, don't say that around me. Supervisors can't do that. They'll be held responsible. You know, so I say it's very easy, I think, for a supervisor to deal, those middle line supervisors, if something happens and they report it, their butt is covered. So that's what I say. Report it, make sure you do it in writing, report it, and just pass it along, but don't ignore it. Lastly, when we're talking about this definition of sexual harassment, I think that this is super interesting. A person who is not receiving employment benefits because they're not having sexual relations with the boss, but the person who is having sex with the boss is receiving benefits, like maybe a raise, coming in late, having a long lunch, whatever the case may be. The person who is not having sexual relations with the boss can file a charge of sexual harassment. I thought that's like an interesting little caveat there. Did you have anything that you wanted to add? Okay. Let's see how much time we have left.
Tina, I have a question.
Yes.
I'm wondering, when you talked about the McDonald's case specifically, and you said that the workplace said that they were not responsible.
Did I say McDonald's? No. Fast food.
Oh, maybe not.
Fast food?
Okay, yeah, but you said that the employer was not responsible. We're claiming that they were not responsible.
Right.
I'm wondering what impact the Mancini Supreme Court decision has had on your cases. There used to be a time before that decision where individuals were able to be held liable, and just wondering how much of an impact that's had on the Commission's work and the ability to hold people accountable.
Thank you for asking that question. I believe that it was, the Mancini decision was a very tough decision for the Commission because we believe that the individuals should be held liable. If individuals are not held liable for sexual harassment and other types of discrimination, it gives them the opportunity to continue to do so and not to, have any repercussions for it. So if I got one wish, I would want this for Christmas, my birthday, anything, that we, put individual liability in the law so that we can start to hold perpetrators responsible for their actions.
I agree with you wholeheartedly. Let's hope you get your birthday Christmas wish.
Thank you. So we have a few minutes. Does anybody have any questions?
I didn't get to read the whole package, but is there statistical data on?
Rep, would you go to the microphone?
I didn't get to go through the whole package, but is there statistical data within the package of how many cases statewide, nationwide, that type of stuff, that instances of claims, and then the number of claims that were how they were adjudicated, if they were in fact considered sexual harassment and that type of stuff?
Well, we could certainly get that information for you.
Yeah, just for giggles, I'd be interested in it.
Okay. Well, I'd be happy to.
Thank you.
So I'll get your email address after the session.
Send it right to the speaker, everybody wants it.
Yeah. Okay. Okay, so I think that I have a few sexual harassment scenarios that we can discuss, and we can, there's a couple of questions that we can ask ourselves. If a person could the person file a charge with the Commission for Human Rights, okay? What kind of sexual harassment is it, if any? Is it quid pro quo that we've talked about, which means this for that? Or is it hostile work environment? Or could it be both? All right, so those are the questions that we're going to be thinking about. And so I don't think I put these in the packet, but I'm going to read them to you, okay? So Dory Aslin is married and employed at a law firm. She is asked daily by a very important client to join him for a romantic dinner. He insists that she will not be disappointed. Her polite decline does not seem to stop the invitations. When she expresses her concern to her employer, her boss replies, "You can't blame a guy for trying." So I guess the first question is, do you think that Dory could file a charge at the commission?
Against her boss? Yes.
Yeah, so she could file a charge. So what kind of sexual harassment do you think this is? Is it quid pro quo? Is it hostile work environment? Is it both? Yeah, hostile work environment, because every time this guy comes in, he's asking her out, and she, and she doesn't want to. Well, whether she's married or not, she just doesn't want to. So she goes to her boss, and he says that, which is, you can't blame a guy for trying. What should he have done? Which we talked about before. Maybe I didn't hit home with it, but an employer, once they get a sexual harassment complaint from an employee, they need to take immediate, appropriate, and corrective action. So who can tell me what they think the corrective action could be here? We know immediate means within a reasonable period of time, right? So appropriate and corrective, what do you think that could be? Yes?
That he would have to speak to that person and maybe express he doesn't go along with that happening in his law office and speak to the person directly and else.
Right, so I think the employer should do what they need to do to get this to stop. So the first thing would be to talk with the client and explain, that this isn't how they run their law office. Some people, when we talk about this, they say, well, maybe Dory can work with another client, and someone else can take over this person right here. So what do you think about that? You think that would be okay? Right, because it sounds like it's victimizing, again, the victim of sexual harassment. So because she was sexually harassed and complained about it, then, if you take a client away from somebody, it could be the fact that they even lose money because of it. So that would probably not be appropriate corrective action, unless the boss worked it out where they changed clients around where the money was comparable or something. So this is the kind of stuff that we talk about in mediation, because there is no real one correct answer. But the thing that I do worry about, my concern, is that when a person complains about sexual harassment, that they are victimized. I had a case where a waitress was being sexually harassed by a cook. This owner owned 3 restaurants, one in the middle of the state, one north, and one south. So she worked in the middle of the state, and because she complained about sexual harassment, the boss sent her to the restaurant down south, which put more wear and tear on her car, more gas for her, more time away from her child, more money for daycare. So this was not immediate appropriate corrective action at all. She did file a charge because of that, and she was successful. It cannot. Action taken after an allegation of sexual harassment cannot harm the victim. So, whoops, that's super important. Okay, let's try one more. I think we have time for one more. We do. So Haley Brady is at a local bar celebrating a coworker's raise. One of her coworkers asked her if she would like sex on the beach. She immediately leaves the bar. The next day, she complains to her supervisor, who counsels the coworker to avoid sexual language with Ms. Brady. Ms. Brady wants her coworker to be fired. So, do you think that Ms. Brady could file a charge? Yes.
I think she has a complaint. The employee could be spoken to, but I don't think anything could happen to the employee because she immediately left. She did not make a comment back to the individual to tell him to stop. She just complained the next day.
Okay. Thank you. Were you going to say something? Or are you on your way out?
Yes, ma'am, I'm not on my way out. You can't get rid of me. Sex on the beach is obviously a drink. If you're in the bar, it all depends on the connotation. If you want to have a sex on the beach, and it's appropriately approached in that way, it could be a question that would not be sexual harassment. If I say, do you want to have sex on the beach, that leaves everything open to whatever the person's interpretation is, and I think that that would be inappropriate or considered inappropriate.
I'm surprised nobody mentioned
Yes.
that this is not in the workplace. Does anybody have an issue with that?
It doesn't matter. You're with your coworkers, and sexual harassment doesn't have to happen in the workplace. It can happen anywhere.
Right.
And I think that there are other drinks, and I could name them all if you want, but there are drinks that have body parts and things like that that could be the same type of situation.
Right, so exactly the fact that this was not in the workplace, because they were celebrating a coworker's raise, well, we do look and see if something can be considered company-sponsored. You know, some employees that go out on their own, I wouldn't see that an employer would necessarily be liable for that. But if there's evidence that it's company-sponsored, then the company, you know, definitely could be liable. So yes, sex on the beach is a drink, and we're not really familiar with all the circumstances there. Was everybody else drinking sex on the beach, or was he saying it to be fresh? We don't really know. But he does get counseled the next day by his supervisor, right? Do you think that that's immediate, appropriate, and corrective action? I do. I do. And so Ms. Brady wanting her coworker to be fired, is that reasonable? No. No. Right. Okay, well, I think we're done, if anybody doesn't have any more questions. We really did speed through that. I was worried about the timing.
Thank you very much, Ms. Christie. Ladies and gentlemen who are listening in, I just want to announce that Leader Filippi has been online through WebEx, and he was present in his ex officio capacity. If there's anyone else that wants their attendance annotated, can you please let us know through the mic, or if you send us through the chat, I'll make sure to announce your name. Thank you all for your attention. Chairwoman McEntee.
I wanted my presence noted, Madam Chair. Thank you.
Chairwoman, this is Ruggiero, and I've been here too. Thank you. Great job.
Thank you, Chairwoman. I see Representative McLaughlin also would like to have his presence annotated. Oh, and also Chair Vella. No. I'm sorry, I don't have glasses on.
Rep. Fogarty was present.
Rep. Fogarty is that Jello? Rep. Jello is here, and okay.
Rep. O'Brien?
Dr. Kazarian.
Same as an out.
Chairwoman, Representative Slater?
No, Mary Messier. Okay, and Representative Messier.
State Rep. Grace Diaz.
We've got you, Chairwoman. Okay. Rep. Corchevant? Shawcrass, good.
Williams is on.
Newberry, Potter.
Donovan is on.
Okay. All right. Is
Casimiro is on.
What about Representative Chippendale? Did you see? He's grabbing it from the chat, yes. Good.
Bob Craven.
Yeah, we have you. Okay, are we good? All right, thank you, everyone. We got you, Chairman.
Chairwoman, could you please add Rep. Steve Lima?
Representative Lima, we have you.
Representative Phillips?
We have you, Representative.
Thank you.
We have you, Rep. O'Brien.
Rep. Corcoran?
We have you, Rep. Corcoran.
Thank you.
Thank you.
Rep. Beer?
We have you also, Rep. Bia. Thank you.